Okay, this is important background for take-home test number 1. So if you're still a little confused about what information you need to provide as part of a permit application, then stay tuned. You've seen this lots of times before. This is the real guts about how to find the information that you need either to submit a particular permit application to or to evaluate it. So in this task, I'm asking you to outline what information needs to be lodged, which will require you to look at a planning scheme that details what's required, and then apply that in a particular case study. Doesn't matter what it is, but you'll need to find something current so that all the documentation is there. And then some background to jump from that specific case into why it's important to provide that information, who might be involved in your particular case. So you'll need to think about who might have an interest, whether they're neighbours or people who don't live in the area. And then planning students need to have a go at whether the application falls into permitted, discretionary or prohibited use. I'm not going to cover that here. That content will come later. Okay, so just to kind of go back to first principles here about why we're controlling for development. So as part of the objectives in our planning system, we pledge to make things fair, whether that's between generations or in balanced conservation and development. We pledge to make sure that people have a say. So development control is about balancing that public interest versus private property rights, which is often quite a tricky balance to achieve. And it's a balance between an authority, a regulator, being able to adequately plan for development. So the schematic here shows uses separated, but also those linear connectivity of roads and railways. And so regulators and government have the responsibility for this overarching network, this regional perspective that an individual development fits into. This is where people with spatial skills are really important for being able to interrogate and represent spatial data. And RUMPUS, our Tasmanian Resource Management and Planning System. So by now you should know that it is hinged around these 5 objectives that get to trying to sustain development. So there are 5 key acts. You should know about the state policies, of which there are only 3, even though it's quite a powerful instrument. The regional strategies, so we have interim strategies that the interim planning schemes have hinged from, the planning schemes that sit underneath each local government, and we have all of that wider context of legislation that helps deliver the objectives of the resource management and planning system. Of course, we also now have a single statewide planning scheme that's in effect but not actually effective until the local provisions are written. So that's what 2017 holds in terms of each local government area taking the state planning provisions and then fleshing them out with local planning provisions, which will in most cases allow for some kind of local area planning and particular precinct plans that will complement this generic statewide planning scheme. So just again also to remind you of the 5 objectives, because it is important to keep coming back to the fact that the planning system is supposed to maintain these balances, to maintain our ecological processes, to encourage public involvement, to provide for a fair system, so whereby we can use our resources but not deplete them for further generations, where we can have economic development that's in accordance with these objectives and not the slow erosion of ecological processes and orderly development over time. And importantly, and this is a really tricky one, is to promote the sharing of responsibility for resource management between different spheres of government, community and industry. This is where the fun of politics comes in, fun and frustration, and all the different perspectives that people have that so often conflict. So these objectives are common to all the legislation that makes up the resource management and planning system in Tasmania. And to remind you too that those 5 acts are LUPA, which should roll off your tongue shortly if it doesn't already. EMCA, anybody who's done environmental impact assessment with me and Lorne will know all about EMCA. It's of peripheral interest in this unit, but any development that requires some sort of more thorough environmental assessment triggers EMCA. Rob Nolan spoke in detail about the State Policies and Projects Act, and we've got the 2 acts that set up the authorities, the Tasmanian Planning Commission and the Tribunal, and we'll go to the Tribunal and meet Jared later in the semester. So hopefully by now you've also read Chapter 4 of the Environmental Defenders Office Handbook. This is a direct cut and paste out of that handbook. It really is a great introduction. So if you haven't read it already, then please have a look at it. Okay, and the other things that we've covered so far is changes to the state planning scheme. So the draft state planning provisions were provided to the Minister a couple of years ago now. There was lots of consultation done in 2016. In March 2017, Peter Gutwein declared the state planning provisions in his role as Minister of Planning. And so what's happening over 2017 is that local planning authorities are preparing the local provision schedules that will include their own maps, particular purpose zones, specific area plans, anything that needs to be implemented to make sense at the local scale. So this is where the devil's in the detail, and we'll see whether the system does end up being fairer, faster, simpler. Then the Tasmanian Planning Commission needs to approve these, Council needs to advertise, and the Tasmanian Planning Scheme becomes operation in each municipality, in each local government area, as those local provision schedules are made. So we'll talk about this later in the semester, but there'll need to be some pretty thorough consultation on state policies. We'll have a look at the Victorian system and see how effectively state policies are used in Victoria and why it's problematic that we only have 3 here. And also talk about the government's intention to deliver on reforms that would allow them to give in principle approval for major projects, strengthen call-in powers, and changes around third-party appeals. So that will come down the track. Okay, so in order to understand the information that you need to provide or evaluate as part of a permit application, you need to be able to read the planning scheme. This is the template that's provided in the state planning provisions for councils to write their planning schemes. So this template requires councils to have parts A through F, where A states the purpose and objectives, and as we've seen, the objectives are often quite lofty and aspirational that set the tone of what the local government is trying to achieve. Administration has all sorts of really important directions about definitions. Much of this is being dropped from this template into the local area, and so part of the intention is that the administration is pretty standard, definitions is pretty standard. You don't get a shop called a store somewhere else, and all of that confusion that has happened and hasn't helped, particularly when things get nasty and they go to legal appeal. Special provisions, zones, codes, we'll talk more about this in week 4, but just to be aware that you will need to be able to read a planning scheme to find information. Then in terms of issuing of permits, under the planning scheme, there are various categories of permits. So there's exempt use, where there's an exemption for needing a permit. You might be rearranging internal walls in your house. You don't need a permit. So there's cases where the use is exempt, or development is exempt. So you might be putting a shed up in your backyard, and you don't need to do anything. No permit is required is a slightly different category, but same effect, no council action. There's permitted use, where council basically has to issue a permit. So the development meets all the standards, and really council doesn't have any wriggle room in terms of the politics of the development. So if they don't approve the development, then the developer or the proponent is able to appeal. So they could take council to the Resource Management Planning Appeals Tribunal and say, this is not lawful, you need to issue us with a permit. And council wouldn't have a case, and it would cost them money. They'd get costs awarded against them for just not doing their job. The use is permitted, but it invokes performance criteria. That means that there's some sort of discretion involved. So council must issue a permit, but can condition the discretion. So some aspect of the height or the distance from the road, something about that development means it's a permitted use, but the actual performance criteria are slightly outside the straight up standard. So council can issue a permit but give conditions on that, that the house needs to retain its chimneys, or that's a common heritage condition in heritage areas. The use might be flat out discretionary, in which case this is where it triggers all of the notifications. Council doesn't have to issue the permit, so it might get to the point where it's refused, or it's subject to quite a lot of conditions. And then there's the case where the application is for a use that's simply prohibited. So we might not be talking about a brothel in a residential area. It might be a shop in a residential area where shops aren't allowed. We'll get into some of the problems of zones being quite restrictive later, and so some of the things that I bat for in terms of advocacy for healthy places and spaces is that sometimes zones are very restrictive in terms of the kind of aspirations that we have for healthy, livable communities. So sometimes a use that seems pretty reasonable in terms of, say, being able to put a shop underneath a flat, it's just flat out prohibited, and council don't have any option but refuse that development. So when you're in iPlan and maybe you typed in your home address and it shows you which planning scheme is applicable, then you'll see in the kind of drop down menu on the left all of these different parts: purpose, administration, provision, zones, codes, etc. And so have a play around with this, but basically this is the kind of order of things that you need to check through. So particularly if you're acting in the role as a council officer and you'll be putting yourself in these shoes with respect to the planner's report, that is a further assessment. So the scheme is intended for you to first check the zone. What zone are you in? Are you in a residential zone if your development is a residential development, or are you in some other zone? Check the use class status. So what are you proposing the development is for? Is it a petrol station? Is it a shop? Is it a residential use? So look at that. Look at the standards in that use class and check for any overlays. So you might find a heritage overlay that you were unaware of, some other kind of biodiversity overlay that could have implications for the kind of information that you need to provide when you're putting in your permit application. And of course, if it's got any special area or local planning provisions, then you'd need to be aware of them too when you're providing information to council. And this is a point that I'll get back to. So you might not be aware of everything that you need, in which case council will come back to you and ask you for extra information. So under administration, this is in the Hobart Interim Planning Scheme, and many of you will be choosing Hobart examples for your take-home test 1. So go to part B, go part down to assessment of application for use or development, and go to 8.1 application requirements, and it will list in some detail what information they require you to submit with your permit application. So this is a pretty straightforward answer to that first part of the take-home test 1, and you'll find it here. I know that the manual for this unit is essentially kind of legal background for planning that makes it quite difficult to read. Nevertheless, there are parts of that manual that are just invaluable in giving advice about most of the assessments that are in this unit. So pages 14 to 17 are the valuable parts for take-home test 1. And so on page 14, this is the bit that you need to get to, the adequacy of information that accompanies the permit application. Rob Nolan's taught me to say permit application because the permit might be applying for change of use, such as Airbnb from a private residential use. People often do say development application because in most cases we are talking about developing the land, whether that's putting in a front fence or an extension, knocking something down. It's more correct to say permit application, but there you go, you'll see both. Specified information required under the planning scheme, this is highlighted here, may include maps, titles, might require reports from experts, so you might be required to get a botanist to come in and look for threatened species. Anyway, have a look through that administration part of the applicable planning scheme because it will say. Failure to supply information that is mandatory when lodging a development application will normally invalidate that application. So it's not a valid application and the clock doesn't start ticking for council until you've submitted a valid application. So in essence, this first assessment is encouraging you to get around what's required in this very first part of the process where you haven't submitted application, you're gathering your information. So I'm asking you what information is required. So the wording of the particular planning scheme that you're submitting to might not be completely obvious exactly what information is required. So this is where it might not be all that straightforward as to what information is mandatory to mean that you're submitting a valid application. And just to point out here, there's quite a lot of case law in this manual, and this is important because these cases that have been decided that are referred to in italics throughout this document, this is basically setting up the rules and changing the rules bit by bit as judgments are made. And so case law is this ongoing development and refinement of the rules. And so in explaining the rules, what Jared has done here is gone back to the relevant decision that sets up those rules. So it might be a little bit intimidating to start with, but once you get the hang of case law, it'll become easier. So this is case law that pertains to failure to supply information, and the judge says in his judgment here, essentially the issue to be decided is whether or not the decision maker, in this case the council, when exercising a discretion as to whether or not to grant a permit, could have reached the view that it reached, having regard to the information that was provided. So the law and the judgment often comes back to what's reasonable. Was a reasonable amount of information provided by the applicant for counsel to make a decision? So where it's not entirely clear exactly what information is required for a valid application, the law falls back on what's reasonable and often makes reference to ordinary people. So it's not what's reasonable to learned judges and counsels who know this backwards. It's what could be reasonably expected for the ordinary person to understand. So this is where we come back to the objectives of the planning scheme and the emphasis on public participation. Judges will always come back to what it's reasonable for a person to know in order to have comment. Okay, so that's page 14. The next page of the manual emphasises that applications don't need to be perfect. The amount of information needs to be reasonable in order for counsel to make a decision, for your neighbours to know what you're doing, to reasonably comment. So again, this is text out of a judgment. So where it's a judgment, I've indented to set it apart from Jared's commentary. An application does not have to be impeccably correct. An application is correct if sufficient information for the purposes of assessing compliance or non-compliance with a substantive planning scheme. Yeah, that's basically it. So if there's enough information to judge the type of development, then good to go. The other important thing, and this comes up quite a lot in planning, is that each case has to be dealt with on its own merits. So there needs to be common sense applied in terms of what information is reasonably required to make a valid application for people to think about their opinions and the effect of that development. So a failure to provide this mandatory information, which most of the time is clear but not always, is a lawful basis for counsel to refuse a development application, so under section 51 of the Act. So in order to make a valid application, you need to provide enough information. There might be argy over what that is, but there you go. Page 16 of the manual says that if there wasn't enough information, the result is an invalid application and you have to go and have another go. So again, this is from a judgment. This was a case that included the state policy on the protection of agricultural land. That's what PAL stands for. And so in this particular case, the person applying for the permit didn't provide enough information about how the protection of agricultural land was affected by the development, and they ignored the zone standards, intents, aim and objectives. And so the tribunal, this is a really critical judgment that can be quite buried, but the tribunal finds that the applicant's failure to substantially comply with providing enough information resulted in an invalid application. So they either give up or they have to go back to the start and try again. The last bit of the manual that's relevant to provision of information is on page 17. And so this is going to the heart of material that's needed for advertising and the whole concept of people being given enough information so that they can have their say. So this is highlighted. Many planning schemes make reference to certain information needing to accompany the development application. So tribunal has a look at what that actually means. What does accompanying mean? It might not mean that you put it in up front, but The second bit of highlight here says it's critical note that the information required by council to assess the compliance must be provided during the assessment process. So all of the mandatory information needs to be up front, and then once that valid application is submitted, the clock starts ticking for council in terms of needing to comply with deadlines about giving you a decision. But there might be a bit of ongoing provision of information. So the term accompanying is a bit elastic. This is the highlight at the top here, in that the documentation may not necessarily have to literally accompany the development application, but will depend on the circumstances of each case as to whether a cut-off date exists that would affect the ability of decision. So there's a whole lot of stuff that has to be given, and then there'll be a bit of backwards and forwards, often even in the case of quite simple applications between the planner and the person proposing the development, or the planner and the neighbour. So in the case of my neighbour's extension on their house, we had a bit of backwards and forwards about retaining some of the features on that site. I wanted some of the trees retained, and the planner wrote back and said, that's actually not in the planning scheme, and I understand, but we can't put that as part of a permit condition, which was interesting. But there were other things about the current condition of the property that could go in as a condition. So that's the guts of what the manual says about information, and then there's a little bit of information on pages 45 and 46 about additional information. So you might submit a valid application, and then council might come back to you and say, we also need a parking study, or we need a botanist to go out and survey for threatened species. So this would be a request for additional information by the council planner back to the person doing the development. So section 54 of LUPA is where the rules are for providing information. So it requires the applicant to provide the council with additional information before it considers the application. So again, this was mentioned by Danmar in week 2, that the actual period of assessment that's advertised, that politicians complain about because it's quite long, can also include a lengthy period where actually for council the clock has stopped and it's the developer looking for additional information. So it's kind of a little bit unfair on council in terms of including that. But anyway, that's how that works. Page 46 is around the length of time that is needed for further information. So the decision to request further information must be made as early as possible after lodgement of the development application and prior to undertaking advertising of a discretionary proposal. So if your proposal requires that council put an ad in the paper to say so-and-so wants to put up a new front fence, demolish the back part of the building and put an extension on, it's often discretionary, it needs to be advertised. Actually, all of that information needs to be provided before it's advertised, otherwise there'll need to be some re-advertising. Mistakes are made, but it costs council money and it costs people time if it's not done right. So this is where it's really hard for council planners, because there's pressure on them to get it right from the get-go, to do it quickly, but they're usually just so busy in terms of keeping all of these balls in the air at the same time. So this is where they're really feeling the heat in terms of getting to applications fast enough to figure out what's missing, to know whether they can go ahead and advertise, ask for additional information and hold off. So yeah, it's often a difficult task, and it's better to get it right from the get-go, but that's not always possible. So I hope this has been useful in terms of giving you a better understanding of what we're asking you to do in Take Home Test 1. And for planning students, we'll get to the issue of deciding whether your application falls into permitted, discretionary or prohibited use in the next session.